Good morning. Hinda Klein here on behalf of Mr. Hernandez. I'd like to reserve 3 minutes for rebuttal. As this court is aware, this is an appeal from an order granting a new trial after a jury returned a verdict finding no future pain and suffering, $50,000 in pain and suffering, and $230,000 in past medical expenses and nothing for future medical expenses in a case in which Ms. Heikka was injured after a motorcycle accident.
Would you agree that our standard of review on an order granting a motion for new trial is more deferential than an order denying a motion for new trial?
Absolutely it is. However, where at least part of the order, as we contend in this case, is incorrect for legal reasons, then this court does not have the obligation to defer to the trial court. If the trial court made an error of law, which we contend was the primary basis for this order granting a new trial.
Well, if there's one error, does that negate all the other grounds that he granted the new trial on?
No, it does not. We're just making the point that the primary grounds, according to the court's comments during the hearing on the motion for new trial, was the jury's failure to ostensibly follow the court's instructions when the court instructed the jury to consider future pain and suffering and to award something for it.
There was testimony that supported that future medicals, right? And pain, or future pain and suffering.
Well, there was disputed testimony on that. Actually, there was a lot of testimony that the plaintiff really had healed quite well over the years, that she had not been compliant with her doctor's orders, that she had not followed her physical therapy recommendations, and the defendant's expert witness actually disputed certain of her testimony regarding an altered gait, for example, and her kicking her ankle.
Was there any dispute by the defense that this was a permanent injury?
No dispute.
So wouldn't she then be entitled, almost as a matter of law, to some amount for future pain and suffering?
No. Under the case law is very clear that there is no black and white requirement that even in cases of permanent injury, one obtains an award for future pain and suffering. And this is one of those, frankly, rare cases where the record fully supports the jury's initial verdict. And the trial court was clearly in error in making the mistake of sending the jury back for reconsideration and then basing his motion for new trial on the jury's second verdict, in which it split the $50,000 it had awarded for past pain and suffering.
Right, wasn't that part of the problem, though? They awarded a certain amount, and then when they were told to go back and award an amount for the future, they took part of it away from the past and put it in the future, and it was still the same amount of money.
That's correct. But
In a rather short period of time, I might add.
yes, 6 minutes, but that in and of itself is of no moment. They had deliberated far longer for the initial verdict. But as I argued, if the trial court was in error in sending them back for the second verdict, and the second verdict ostensibly split the pain and suffering between past and future, then frankly there's, at the end of the day, no error, because the jury shouldn't have been sent back in the first place. The $50,000 in past pain and suffering should have been basically confirmed by the court, and if the court had a problem with future pain and suffering, because the law doesn't require that the jury be sent back based on an inconsistency in its verdict, then the court could have addressed that on a motion for adder, which it declined to do.
Did the defense object to the case being sent back?
No, the defense did not. I think.
Then why isn't this a waiver?
Well, we're not here appealing the fact that the jury was sent back. We're appealing the trial court's order granting a new trial. And we're merely making the point that one of the grounds for granting a new trial was, frankly, in the court's error and misunderstanding that the jury was required, as a matter of law, to award future pain and suffering in a case in which there is evidence of a permanent injury.
What about the finding by the trial judge that the manifest weight of the evidence didn't support this, and therefore he granted the new trial? How are we supposed to review that?
The manifest weight of the evidence.
His finding of that as one of the bases for his new trial.
Right. Well, clearly the manifest weight of the evidence more than supported that. Even the plaintiff testified that basically she had pretty much healed, that she was enjoying life the way she had, that she hadn't been to her doctors in something like 4 or 5 years, that she was back on a motorcycle, that she was swimming, that she was dancing. The evidence was undisputed that she worked for 2 years lifting 50-pound boxes for a company, and pretty much all of the evidence showed that she wasn't suffering any future pain and suffering.
So she has a pretty horrible scar on the back of her leg.
That correct, but she also testified very clearly that she had come to terms with it, that she was happy with the way she looked, that she had a boyfriend for 5.5 years. He accepted her the way she was, and I think on balance, the clear manifest weight of the evidence, if anything, was in favor of the zero damage award for pain and suffering, and as support for that, I would cite the court to the case of Ortega versus Bologna, 185 Southern 3rd, 538, 3rd District, 2015. And this was a pretty bad case where the plaintiff had suffered a broken neck and was awarded $5,000 in past and future pain and suffering. The trial judge in that case granted an additor of $250,000, and 3rd District reversed, finding that based on all of the evidence, the plaintiff had effectively healed, was very stoic, and that, well, it clearly appeared low, it was not sufficient to award an additor in that case, and the court reversed for...
Here's the problem. I mean, we've looked at the pictures of the scarring. The scarring is really significant. And the judge sat through the whole trial. And I guess, it feels to me, reviewing this case, like, that the judge, having sat through the whole trial, looked at the damage award in this case, and it's kind of what we see for soft tissue cases with no scarring. And so, isn't that the judge's call, that if he's willing to sit through another trial, don't we have to defer to him on the manifest weight of the evidence? It's because it's certainly not a soft tissue case. The scarring is pretty significant.
I don't think so, because, as I said, there was significant evidence that, first of all, that her past pain and suffering was not necessarily as bad as she indicated. She was caught on several occasions basically lying during her testimony. The jury had the ability to evaluate her demeanor, and while I certainly can't dispute to this court, and I've put it in my brief, that this is somewhat of a low verdict under the circumstances, it's not out of the realm of possibility given the big picture. And the court, under these circumstances, we contend, was acting as basically a seventh juror. I would have awarded more money, and therefore I think this is necessarily against the manifest weight of the evidence.
But the judge did use the correct words in doing it. He didn't say, like, if I were the seventh juror, I would have awarded more. He basically said the legal terms that support a decision like that.
And I would submit that in most of these cases, the courts use the correct verbiage in doing so, but that doesn't necessarily mean their decision at the end of the day is really predicated on the manifest weight of the evidence versus what the court might have done.
To what extent does trial counsel on your client's behalf acquiesce in sending it back to the jury eliminate the issue for you?
I don't think it does, because at the end of the day, whether the court looks at the first or the second verdict, the trial court was basically wrong as a matter of law in its conclusion that the jury had to award something for pain and suffering. Essentially, what I'm arguing is basically it was harmless in the scheme of things, and the ultimate error still remained, regardless of whether you looked at verdict 1 or verdict 2.
What about the other issue on the new trial, that the judge found that the testimony, again, elicited by your trial counsel, that he had been making payments, that all this sort of irrelevant stuff that the judge found. Why should we disturb that finding, that it was part of the reason why the new trial was necessary? All that stuff shouldn't have come in.
Well, I mean, there's nothing in this record that shows how that might have affected the jury, and second of all,
Who has the burden of that? Who has the burden of showing that?
We have the burden on appeal of showing that. But at the end of the day, I don't see how that specific testimony, taken literally, taken as it is on the record, demonstrated any kind of wealth or poverty of either party. As a matter of fact, the plaintiff herself talked a lot about, her own difficulties, that she had been unemployed, et cetera, and I don't see how the testimony of the defendant, that he was a line cook, that he had 2 kids, was evidence of wealth or poverty, nor do I see how evidence of any payments he was making had any effect whatsoever on this verdict. The jury was very clear in what it wanted to do. It wanted to compensate the plaintiff for her medical expenses and some amount of her past pain and suffering in recognition of the length of time that she was in the hospital. But this jury did not believe that she was going to suffer any future pain and suffering, and it was virtually undisputed on this record that she was not going to suffer any future medical expenses. And therefore, I just don't see any connection with the admission of that evidence and the necessity for a new trial. And I understand I'm into my time, but I did want to just make one last point, and that is, if this court were to affirm the trial court's order granting a new trial with respect to future pain and suffering, there's absolutely no reason on this record that it should affirm the trial court's decision to award a new trial on all elements of damages. There's no question that the medical expenses awarded were entirely consistent with the evidence, and there's just no reason to award an entirely new trial. Thank you.
Good morning, Your Honor. Ken Cooper on behalf of the appellees. Basically, I'll open it up for question because once upon a time, Judge Poland said, Mr. Cooper, you may not want to say anything. But do you have any questions for me? I believe the scar is a permanent injury. There's no doubt about it. Judge Rodriguez put it in his order. It was undisputed. It's a horrific scar.
Even though that's undisputed, is the jury required to give some amount, even $1,
Yes,
on the future pain and suffering?
Yes, sir. And I believe Judge Gross affirmed that opinion in Garrett versus Miami Transfer. And I think the Supreme Court said the same thing that you followed in that opinion. And the distinction between those opinions is whether or not there is undisputed or disputed evidence as to whether there's a permanent injury or not. If there is a disputed issue as to whether it is permanent or not, the answer is you do not have to award future. But the fork in the road and the line in the sand, if it is undisputed, which in this case it was, and Judge Rodriguez puts it in his order, it was undisputed. And in their brief on page 4, 5, and page 31, they admit this was a permanent injury and that's undisputed. Therefore, the answer is under the law that you wrote, you do have to award future medicals.
If we were to agree with you, should we limit the new trial to just the elements of damage that the trial court found was against the manifest weight of the evidence? Why should there be a new trial on everything?
Well, I think that in Judge Rodriguez's order, he says the grossly insufficient award was caused by the influence of passion and prejudice. And
What was he
if
talking
you-
about, though?
I understand. If you look at, she had 5 surgeries. She had a skin graft. She was in the hospital for 45 days and 3 months of rehabilitation. Does that justify 25 grand in past pain and suffering? And that's what he puts in his order. Because he puts in his order that the nurses actually had to change the bandages, and he was the one at trial watching his testimony, and he's the one that said these were horrific injuries. This was not a little bit of pain and suffering. Every time they had to change the bandages, she screamed, cried in pain, and she was on pain medication at the time, and it still hurt that bad.
So it's your position that not only was the jury incorrect in not awarding future damages, but the past pain and suffering damages were also too low?
Yes, Your Honor, and Judge Rodriguez actually cites that in his order and says that. And I will tell you this, since presumptively, I try a fair amount of cases. This is the second time the defense lawyers are using this poverty defense to prejudice the juries. And I looked at it, and I've read that Supreme Court decision, and it is their burden to prove that it did not affect the jury. This must be going on more than I understand. This is the second case I've had where they've done it. And as soon as they said, I got 2 kids to support, and I'm divorced, and I'm working in a job, that's where the prejudice came from, I believe. And this must be going on more than I'm aware of. But if I was to say the fork in the road, that's where the jury went. If we give this girl a large award, he can't feed his kids, and he can't support his family. And that's where I think, and I had this happen in another case, and you could just feel that jury turn on you. And it was not right, it was not proper, there was no reason for it. And he cites it in his order, and they never proffered any proof that that did not prejudice the jury. But aside from that, I've got a client that's got actually more than 200,000 in medical bills. Be in that hospital and have a skin graft and all of that for 25 grand. Could anybody say reasonable people would not disagree that this judge was correct in awarding a new trial? I mean, I absolutely believe he is correct. It should be on everything and start over. But I do
Including the
think-
medical expenses?
Excuse me?
Including the medical expenses?
Yes, sir. I mean, when you look at this, and I was going to give you this, I wasn't, and I debated it. I've asked trial lawyers for years, what grade do you give a jury? Civil, because I've never done criminal. And the lowest, even from an insurance defense lawyer, they said about 93%. They believe juries are 93% accurate. This is one of those 7%. So, but if you look at it from that perspective, the medical bills were undisputed, stipulated to them, and then in closing argument, he said, if you think these are unreasonable, reduce them. And then they reduced them by 20 grand. I mean, I'm sorry, that's just a really bad jury. And Judge Rodriguez puts that in there as well. There was no evidence why the defense lawyer in closing argument said that. I don't know. He stipulated to them. And then they reduced them by 20 grand. So if you take that argument, yes, she should get all of them. And yes, there should be a new trial on the whole trial. It just was one of those 7% bad juries. I mean, maybe I did a bad job picking the jury. Apparently that was a problem, but every once in a while you get a bad jury, and I think Judge Rodriguez laid out exactly the facts. You would have to find some gross abuse of discretion to reverse it entirely. And so I think he did a good job laying it out. He sat there, and as I said in my brief, I said, he was a former insurance defense lawyer. He's seen both sides of it, and then he did plaintiff work. He's seen both sides of it, so certainly he is a judge that is familiar with both sides, and when he says this just was a wacky jury, it was a wacky jury. Can I tell you? Anything else?
No.
Thank you.
Got about a minute.
Thank you, Judge. First, I'm not sure I spoke properly originally. I don't believe that there should be any new trial other than, if anything, past pain and suffering. Future pain and suffering, there's clearly evidence to establish that she wasn't going to have any.
How could you get to future if you don't explain the past, however? In other words, you would say it would be okay to have it go back only on that single issue, but would you agree that there'd have to be some evidence that would come in about what she went through to get to the future pain? Evidentiary-wise?
Well, there has to be some evidence that she's going to have future pain and
Right.
suffering. And in this case, there really wasn't. That both physicians testified she was pretty much healed, that she wouldn't need any future medical, and that this was as good as it was going to get, but that, the worst problem that she had was a neuroma, and the neuroma itself wasn't painful, and she herself testified that she was back to doing everything that she used to do. So if there's
Let me ask it a different way then. Let's assume we were to agree with you that it should go back only for a trial on future pain and suffering. Would you agree that in that trial, the plaintiff would be able to put on evidence of what she went through?
I don't see how that would be relevant under the circumstances. I think that that would confuse the jury if a new trial was limited only to future pain and suffering and not past pain and suffering. I don't see how one would necessarily affect the other, and while I don't have them at the top of my head, I know that there are cases that say you can't base a future, or juries are not required to base an award of future medical or future pain and suffering on the past, because obviously they're two different experiences. I disagree with opposing counsel's reading of the Garrett case. That was a case where the evidence was hotly in dispute as to the argument or the statement that the amount of medical expenses was stipulated, as I set forth in my brief. At the transcript 176, it was not stipulated. If it was, then there would have been no reason for it to go to the jury. And with respect to the medical expenses, the evidence is clear that they requested $246,000 in medical expenses. 16 of that was interest on $230,000 in medical expenses, and the jury gave her $230,000. So again, there's no reason for there to be a new trial on medical expenses or anything else for that matter. But if there is, it should only be on pain and suffering. Thank you.
Okay, thank you, Ms. Klein.